On your left side, you're going to see a few icons, and one of those icons is a chat icon. It's a little chat bubble. So if you have questions as we're going through this, all you got to do is click on the chat icon and type in your questions, and we'll answer them at the end of the class. So don't worry if I don't respond to your question right away. I am waiting till the end, make sure we have time to answer them. You will get one CMCA credit for this class. That will be emailed to you. It's automatically generated. You should have it within the next 24 hours, as soon as we confirm everyone's attendance. Along with that, you will be getting a copy of the PowerPoint. And so feel free to take notes as I go through this, but you will be getting a copy of the PowerPoint as at the end. Or I mean, with the with your credits, sorry. Additionally, if you have questions as far as technical issues or you're having problems with technical issues, please don't type anything in because I'm not going to be able to help you with that, and I won't even really see it until the end. Instead, you can email education@altitude.law, and you will go to Sean, who is our education coordinator, or you can call him directly at 303-991-2076, and Sean can help you through, whatever technical difficulties you are having. So with that in mind, I think we're ready to start. All right, let's do this thing. All right, so whenever I teach these types of classes, I always like to start at the very beginning. And the very beginning is defining what a master association is. So Kiowa does define it, and in a very convoluted way, and you can read it for yourself right here. This is pretty much word for word what is written in the statute. So it's an organization authorized to exercise powers of one or more associations on behalf of one or more common interest communities, or for the benefit of unit owners of one or more common interest communities. Kind of gibberishy. I suspect you're all going, what? What is this? Yeah, exactly. So the next slide, we're going to try it in English. And in English, it's an association that has authority over or provide services to other associations or owners within such associations. So it's basically what I like to call a blanket umbrella community, a blanket umbrella association that within its umbrella has other associations within it. And so typically when we think about a master association, now keep in mind, this is typically, this is not always, and this may not be what you deal with on a daily basis if you work with master or sub-associations. Generally speaking, a master association is going to be a large-scale community. It's going to have multiple builders. It's going to have lots of residential options. It might have single-family homes in one area, townhomes in another, condos in a third. It's going to have different neighborhoods. It's going to have recreational facilities, and you're going to have this single umbrella master association that kind of watches over everything. You're going to see double assessments and double covenants, rules, and regulations, as well as overlapping duties sometimes between the master and the sub. The best example I can think of when it comes to a typical master association is Highlands Ranch. Okay, I mean, Highlands Ranch is the largest HOA in Colorado. It is, I don't even know how many people, there's like between 40 and 50,000 homes there. It's so big. It's got its own post office, its own zip code, and whatever. So if you've been to Highlands Ranch, or at least you've heard of Highlands Ranch, it is, it's huge. It's kind of many miles long and wide, and there are all sorts of neighborhoods in there. There's older communities like from the 1980s, and then there's still communities that are being built today. And there's anything from single family homes to townhomes to condominiums to patio homes, whatever. There's everything is there, the full gamut. And there's also 4 recreation centers, and they all have pools and workout rooms and all sorts of stuff. So that is kind of that typical setup of a master association. So if you're having trouble envisioning it, think of that. But also, I think some people work better with illustrations. And so I kind of created this very cool, right? Very cool thing, this master sub illustration. So, the big yellow circle is the master. So within the master, we can have different sub-associations. So I did 3. We have the green, the purple, and the pink subs. So for example, any homes located within the green circle would still be homes in the master community, but they would also be homes in that particular sub-association. Any homes located in the yellow portion would just be homes that are part of the master, but they're not part of any sub-association. So sometimes it gets confusing, especially for owners who don't understand how HOAs are structured. They don't understand how it's possible that they've got, to comply with 2 sets of rules or pay 2 sets of assessments or whatnot. But again, this is kind of a general depiction of how the master sub looks. All right. And so why do master associations exist? Well, it's not much different than some metro districts. So for example, you have like this big area of this big community. I'm going back to Highlands Ranch. You got 45,000 homes, right? And there's so many different little sub-associations and different factions, different communities in there that have their own separate governance because they have to, because they're small, they're on a local scale. And so the master association is kind of this big umbrella that goes over all of the property. And generally we're looking at, making sure that the whole community has a certain feel to it, even though there may be different neighborhoods. And also to make sure the quality of the construction and everything else in the community is fairly consistent to ensure property values. There's lots of different reasons why people say that masters are created. I think overall, though, it's kind of this, it's kind of like a county versus a city, right? So within a county, you can have multiple cities and the cities kind of do their own thing, but then the county oversees that. And so it's the same type of concept when we're talking about the master association. So now that I've completely confused you, let's get into the meat of this thing. Authority of the master communities. This is where everything goes awry. So I have news for you. There is nothing in state law that governs authority of a master community over a sub-association. We have a definition of a master association in Kiowa. Kiowa has a section that deals with master associations, but for the most part, it only addresses how the boards are elected, the master boards. And it doesn't talk about the specific authority of a master. So you know what? There is no one size fits all. There is no rule. Everything is going to be document specific, and you're going to need to actually look at the declarations for both the master and the sub-association to figure out what their relationship looks like. There is no default on this one. So you have to go through the documents, which is why a lot of times it's something that has to come to your law firm because it is an interpretation of the various legal duties and obligations of both entities. And there's different ways that these can be set up. right? For those of you who manage or sit on boards of master associations or sub-associations, you know, it's not always going to be the same setup. And so, again, we can't rely on common sense. We can't rely on some default provision in a statute. We can only rely on what our governing documents say. All right, comedic break. Enjoy. All right. Okay. So let's talk about, again, a typical setup of a master and sub association. Just because it's typical doesn't mean it's going to be this way every single time. It won't be. But generally, when we think of a master sub association, what we think of is two sets of covenants that have to be followed. And we think of two sets of assessments that have to be paid by homeowners. So when you're dealing with two sets of covenants and rules, ultimately the one that's more restrictive is the one that's going to control. And what do I mean by that? Let's say I live in a sub-association and my sub-association is also part of a master community. The sub-association declaration says no dogs over 50 pounds are allowed in the sub. And the declaration for the master association may say something like no dogs over 100 pounds. So as you can see, the master allows dogs of up to 100 pounds and the sub allows dogs of up to 50 pounds. Now, a lot of people call me with these types of situations and they say, so that means the sub-association declaration is unenforceable because it conflicts with the master. Well, the answer is no, they're both enforceable. They're both enforceable by each respective association. So I, as a homeowner, in the sub, I can get a dog that's 75 pounds. And that's a violation of the sub-association declaration, and the sub-association can come after me and enforce that because I have to comply with these documents. But the master association, I'm not violating anything in the master association, so they couldn't care less that I have a 75-pound dog. Let's say I get a dog that's 125 pounds now. So I'm in violation now of both sets of documents. So the sub-association can go after me because I have a dog that's over 50 pounds, and the master association can go after me because I have a dog that's over 100 pounds. I've messed up both. I've double screwed this, right? So basically, each entity, all things being equal, enforces its own rules. And ultimately, if I have a dog that's more than 50 pounds, I have failed to comply with one of those restrictions, the sub-association, and I'm going to be in trouble. So ultimately, I shouldn't have a dog that's over 50 pounds, and that's the only way I can comply with both sets of restrictions. And therefore, it's not that the master association trumps the sub-association declaration. It's that I have to comply with both. And if I want to comply with both, I got to do what's most restrictive, so I'm in compliance with both. Okay? And each entity enforces its own rules. Dual ARC submissions. We're going to get into some interesting stories on this later on. But essentially, with this process, I, as a homeowner in a sub-association, I want to put a gazebo up in my backyard. I'm going to submit an application for approval to my sub-association, and I'm going to submit an application for approval to the master association. Ultimately, I have to get approval from both to be able to put my gazebo up, or I'm going to be in violation of one, at least, of the documents, either the masters or the subs, and someone's going to come after me for enforcement purposes, right? So sometimes what I see is a master association will say, we're not even going to touch your architectural submission unless you attach a copy of the approval from your sub-association. And some sub-associations will say, we're not going to touch your approval or your request until you show us approval from the master declaration. And so, I mean, from the master association. So there may be like a specific order within which the homeowner needs to go and get approval, but ultimately they need approval from both entities. And again, this is for a typical setup, right? Not all setups. So typically they're going to need approval from both entities before they can put up their gazebo. Same thing with assessments. We have 2 sets of assessments, and they both have to be paid by homeowners. You have to pay your master association money, and then you got to pay your sub-association money, because they both have to function, right, to do the things that they are assigned to do. So, you know, there's 2 separate boards, there's different responsibilities for maintenance, for insurance. I mean, so both associations have a right to collect assessments to fund their purpose. And a lot of times, especially new homeowners that are inexperienced, they end up buying a home. It's in a sub-association and they're getting hit with 2 sets of assessments. They don't know what's going on, right? There's a lot of issues there for those homeowners. So, you know, it's important not just for the boards and the community managers to understand the relationship. It's important for the homeowners too, or else they're going to feel like someone's pulling the wool over their eyes. But there are other ways of running a master-sub relationship. So let's take a look at a few variations here. And by the way, I love this meme. And I was laughing so long when I saw it, so I hope you're all laughing because it's hilarious. Anyway, if you're not laughing, I'm sorry. I think it's funny. Variations. All right. Some delegate. Oh, there shouldn't be an S there. I apologize. Oh, no, there should. Sub-delegates. Sub-delegates enforcement to the master association. So that's one option. And I kind of alluded to that, but so the owner only goes through the master association for all ARC approvals. So that in a way makes it easier for the homeowner. I only need to submit my application to one entity and get approval from one entity. And then to the extent that I put something up that hasn't been approved by the master, arguably the master is going to come in and enforce it, but that's not always the case either. Sometimes the master can take on the approval process, but the enforcement process remains with the sub-association. So those are different ways that those variances can play out. How do we know which one? You got to read the documents. That's the one thing I'm going to keep repeating over and over and over again, like a nagging mom, that you've got to read the documents to understand how the relationship is between the master and the sub. There has to be authority in the master association to take on enforcement, to take on architectural approval from a sub-association. There needs to be something in that declaration allowing the master to do that. Otherwise, there's nothing in the statute that allows a master to do that, so arguably it can't do that. And by the same token, we need to make sure that the sub-association's declaration has a provision that says that the sub-association may delegate this duty to the master association. Where it gets weird is sometimes it'll say sub-association can delegate, and so the sub-association's like, okay, here you go, master. We're delegating this to you, but the master says, no, we're not going to do it. We're not accepting this delegation. And then there's like this fight over whether or not there's a duty on the part of the master to take on the specific delegated duties. And normally the answer is no, there isn't a duty because they have to accept it. Okay. But again, there's no, one way of doing it. And, as many sets of documents as there are out there, you can have that many different ways of setting up the relationship. So again, review, or have the attorneys review. So this one is less popular, but the master delegates enforcement to a sub. Some master associations will say, look, we're here to make sure like the overall community feel is good and take care of certain things, but we don't want to be, micromanaging within each individual sub-association. That's why they have boards. That's why they have their own documents. We're not going to get involved. And so basically, we're delegating all of that to the sub-association. And the sub then is responsible for all the approvals, all the enforcement, and all of that. So with this type of situation, though, it can get very confusing very quickly, because then is the sub-association required to enforce the master covenants or just its own covenants? And again, is there authority for the master to delegate all of this? Is there authority for the sub to take this on? And is there authority for the sub to enforce the master community's documents? Typically, you don't see that kind of authority. So, it can get very convoluted. You have to read the documents. Oh, did I already say that? Sorry, you got to read the documents. So you need to know what's in there. And it doesn't always make sense. I'm here to tell you that I've reviewed governing documents for both master and subs where they seem to say completely different things, and you can't make sense of it. Like, they completely contradict one another. And in those cases, yeah, you got a problem. But especially then, you got to get the attorneys involved so they can look through the documents and at least provide some sort of a recommendation. Be careful sometimes, and I run into this, if you have the same law firm representing the master association and the sub-association, they may have a conflict. And either ask for a waiver from both entities or tell you that, look, you're going to have to go to different counsel for this particular issue. I mean, there's only so many, law firms that work with HOAs in Colorado. So at some point you are going to run into these conflicts. And I know I've had to have associations sign off on waivers. I know I've had to turn associations over to other attorneys for the purpose of, these types of situations. But either way, you need an attorney who's looking at the documents for your purpose, for your master association purpose, or for your sub-association purpose. All right, let's look at this other one. So another variance. The master controls everything. Now, sometimes I feel like with our master board members, that is how they think it always is. Like, they think, oh, it's a master community, so we control everything, and nobody has the right to say otherwise. It's all us all the time. But that's not the case, as you know. But some documents are written in that way. So basically, the sub-association has no right to adopt its own rules or guidelines. It has no right to require its owners to submit to architectural approval. It all goes through the master community. And basically, the master community is charged with reviewing the applications, giving approval, and enforcing. But again, there's always a little monkey wrench that gets thrown in here when we have these types of situations, and that is, does the master association have a right to enforce the sub-association's declaration? Because somebody still has to enforce it. Is that right given to the master? And if it isn't, then can the sub-association enforce it, or is that somehow interfering with the master community's ability to do its own thing? So yes, there's always going to be questions on top of questions, and that's where all the confusion comes from, I think. Also, it's, you have misinterpretations of documents, and as far as what it's really saying, and you guys know this, you work with attorneys enough to know that, ask 2 attorneys, get 3 opinions, right? So it's not always black and white. But that's really the only thing you can do, is submit those declarations to legal counsel, because that's what's going to tell us what the relationship is. Let's talk about some common mistakes. I think we've already been talking about them. But as you can see, the mistakes all come from various assumptions that are made by various boards, by various maybe managers, by homeowners and communities, and they all obviously stem from not understanding the relationship, from not reading the documents, or not understanding what the documents say. So again, the assumption that the master association has some sort of control over the sub-association. The assumption that the sub-association cannot be more restrictive or less restrictive than a master. The assumption that the sub is required to enforce master's rules and covenants. There's obviously, we can go through these mistakes. There's an endless supply of them. These are just kind of the big ones. I see an assumption that the sub reports to the master. We've kind of touched upon all of these, you know, in discussing the various setups. So I think it's probably more important at this point to talk about some real life examples and, you know, talk about what actually happens in real life that we've seen. All right, here's example number one. You suck at managing money. These are all true stories, by the way. I'm not making these up. I couldn't make these up. I'm not that creative. So you suck at managing money. This is a master sub-association relationship where the master association heard a rumor. Okay, they didn't even know for sure, but they heard a rumor that one of their sub-associations wasn't properly managing its money, that it was on the verge of bankruptcy, that a receiver might be getting appointed. I mean, they heard all this stuff. And they reached out to me, the attorney, and said, so can we go in there and take over their finances and tell them what to do, since clearly they're not managing their money properly and they're sucking at it? And of course, my gut reaction was, heck no, except it wasn't heck. And I said, well, typically that's not something that a master association has authority to do. But if we want to know for sure, I will need to look at your documents and see what's in there. So, you know, the board gave me authority to look at the documents. And of course, I flipped through the documents and no, there wasn't anything there. And so I told the board, look, I'm sorry you feel the need to meddle in your sub-association's finances, but you really don't have the authority to do that. But this just goes to show that people really get carried away with the concept, I think, of a master-sub relationship, and that there are folks out there, at least they ask though, right? At least they ask, but they thought about the fact that, well, as a master, I should be able to look at the finances of a sub and tell them they're doing it wrong and tell them what they need to do. It may seem humorous to us, but I suspect there may be master community declarations out there that have something stupid like that in there. Just saying, I haven't seen it yet. All right, let's do another example. Go sit in the corner and stop interfering with the ARC process. So this is a story of a sub-association. It was a townhome community. It still is a townhome community. So homeowners owned their lots. And it was part of a master where the master kind of thought it was all that in a bag of chips. And apparently it was, because that's the way the documents were written. Essentially, the sub-association adopted rules. It had architectural guidelines. Homeowners had to go through approval until one day they get a nasty gram from the master association that says, you need to stop this because you're violating our governing documents, and you don't have the right to do your own thing. It's all us. It's all the master. And so I got a call from the manager of the sub-association asking me, is this really true? And so this is a story where the documents were convoluted and they weren't exactly clear as to who had to do what. However, they did defer to the master association. So they acknowledged the existence of the master association. They acknowledged that all the homeowners were bound by the terms of the master association. And the master association declaration did say that, architectural approvals, go through the master, but it didn't say it was an exclusive thing. Like, it didn't say nobody else can do it. But when you looked at the sub-association covenants, there was no specific provision allowing them to review and approve architectural processes. There wasn't even anything that said that exterior improvements had to go through that sub-association. So as a result, because they didn't have that authority in their documents, it ended up being that the master association had the full control at that point. But the master association went really far with this and said, not only can you not do architectural approval, you can't adopt your own rules because we have that exclusive right. Well, there wasn't a provision in the sub-association declaration allowing them to adopt rules or guidelines, but Kiowa allows associations to do that without specific authority. But the master association kept saying, well, no, it's not in your documents, but it's in our documents, and therefore you can't do it and we can. Well, that didn't make much sense. Because how is the sub-association going to clarify what is in its documents if it can't create, rules and policies clarifying those terms? So this did not go to court, thank goodness. It would have been very messy. But basically, the sub-association ended up stopping the architectural review process on its end, and it started to let everything flow through the master. But they did keep their rules in place. They just made sure that none of their rules were really against what was in the rules for the master association. So that's kind of how they did it. Again, it could have been decided differently. It could have, if it went to court, who knows how a judge would have interpreted it. But that's how they moved forward, and haven't heard any peeps from them about this issue the last few years. So I can only assume that it's working for them at this point. But actually, this brings me to another example that I want to mention here, is that I do have another community, another master community that has specific language in its declaration that says basically that the master is going to be the sole exclusive deciding factor with respect to architectural modifications. And then it says, unless the master chooses to delegate this right to a sub-association. And then it goes on to say, the delegation would have to be in writing, blah, 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 blah. But basically, we have a master deck that actually says that, hey, this is exclusive to this master, and the sub-associations do not have authority to do anything unless they have been delegated that power. So this is, to me, that's a little bit unusual. I don't typically see anything that specifically says, this is the only entity that can do it, but just goes to show you that it's out there and really almost anything can go. All right, let's look at another one. Sub must pay for delinquent assessments. This is a strange one. So this was a condominium community. It was really like, I think it was like 1 or 2 buildings with however many units in each building. And the master declaration had the most bizarre language in it that basically said that if the homeowners in the sub-association do not pay assessments or are delinquent or whatever to the master, that the master can demand those amounts be paid by the sub-association. So that's a new one, right? So it's not like the master would go after each individual delinquent owner. It would actually go after the sub-association as an entity. To me, that's just strange, because so you're going to sue, you're going to do a collection action against the sub-association, but how are you going to collect on your lien, right? You can't foreclose on a lien because what do you have a lien on? The buildings? But oddly enough, in that situation, the sub-association had some pretty bizarre language as well. And the sub-association deck said that the association was required to collect all amounts of assessments that were imposed by the master association for the master, and then it had to turn over a check every month or every quarter, I can't remember, representing the total dollar amount of the assessments that were imposed by the master against each individual unit in the sub. Oh my God. So basically this poor sub-association, not only did it have to collect its own assessments, but it was required to collect the assessments for the master. And if it failed to turn over the full assessment amount to the master association, that's when the master comes in and says, hey, you're delinquent, sub, and we're going to impose late fees and we're going to impose interest, and you need to pay us all of this. It's a very strange setup, but I can see how it was done to make life easier for the master association. Definitely wasn't easier, for the sub association. But so that's another really, really odd one. And in the last example, and I see this actually fairly often, where there's something going on in a sub-association, and the sub-association is having a hard time handling it, and they reach out to the master and they ask for help. I've seen this in different ways. I've seen this with an association, sub-association trying to enforce its covenants, and it's having a hard time doing it, and so it wants the master to step in and take over. Or it's having, it has a difficult owner, and it wants the association to step in and handle it. But, that comes from a presumption of that the master is the end all be all and has the right to enforce the sub-association's covenants. And in most of those cases, in fact, I think in all of those cases, I have yet to see a situation where the master said, yes, we will step in and handle this, because their governing documents didn't authorize them to handle the sub-association violations or the sub-association issues. So if you have a nasty homeowner in a sub-association, so someone who is interfering with contractors, just being rude and abusive, consistently bombards the community manager with emails and phone calls. You guys know the type I'm talking about. You've all dealt with them. If you got someone like that, and the sub-association says, oh my God, there's nothing we can do. We're so small, but the master's so big, it should be able to step in and do this. So the question then becomes, is what that owner doing also a violation of the master association? So is this owner interfering with a master community subs? Is this owner bombarding the master board with, emails and phone calls? If not, then that owner is arguably not in violation of any of the covenants of the master association. And therefore the master association can't go after him or her. This is all parallel to a situation with when you call and say, hey, I have an association and it wants to know if it can prohibit chickens when the county specifically allows chickens. Okay, so this is exactly the same analysis. So you've got a county and an association. So there's no master, but you got the county and the association. In most cases, we will say, no, we can be more restrictive than the county. And if the homeowner does something in violation of the county ordinances, then the county would have to enforce it if it's not a violation of our ordinances. County says you can't build, you have a setback of 10 feet from the property line. Association says we have a setback of 3 feet. So homeowner complies with the association and builds something within a 3-foot setback. That's going to be a violation of the ordinances of the local municipal code, but it's not going to be a violation of the association's declaration. So it's exactly the same type of thing with a master and a sub. We can be more restrictive unless the declaration tells us otherwise. I'm sure I made this all as clear as mud at this point. Oh, I love this one. Hopefully I don't offend anyone with the A word, but it does mean a donkey, right? Okay. Actually, we are done with the presentation portion, and I am going to look at the questions now. All right. I can hear, we can hear you, we can see you. Awesome. Okay. Is it required that a sub-association have an ARC, DRC, or can the master ARC, DRC oversee all HOAs? And then you answered my question. Okay, yes, so the answer is yes, it's possible as long as it is in the declaration, right? As long as the declaration for both the master and the sub speaks to that. It would be helpful to have the PowerPoint presentation ahead of time. I purposely didn't do it ahead of time. I didn't want people looking ahead and getting confused. Most of the time we do provide it ahead of time. How does a sub-association remove itself from a master association? That is a really, really good question. So a lot of times you just can't. There's not a mechanism for it, but because what happens is you are within the geographic region of the property that's subject to the master declaration. So for example, the master declaration has an exhibit at the end with a legal description of the property that's subject to it. And that property where the sub-association is described in there. And so essentially it would have to be carving out an exception to that property, even though it lies within the vicinity. And so ultimately, can it be done? Probably. Is it going to take approval from probably like 67% of everyone in the master, 67% of everyone in the sub, and possibly, the board of directors of both communities? At least, that is at least what it's going to take. So it is usually something that we don't see happening very much. If a master has an anti-harassment policy, does that same policy also apply to the sub? Well, so the policy is going to apply to how the master association treats harassment. And it's going to apply to the extent that the master association is involved. It's not going to apply, for example, with a sub-association board and how that board acts. So again, this is going to be a policy that only binds how the master association acts. It's not going to bind how the sub-association acts. Hopefully that answers the question. Can you go through an example of the setback county versus association again? Absolutely. So, in fact, I just had this situation come up. Counties have their, own ordinances, and sometimes it'll say you can't build anything within a certain, distance of the property line. So you could have a county ordinance, and I'm just throwing round numbers out for an example, 10-foot setback. In other words, you can't build anything within 10 feet of the property line. It has to remain unbuilt. But the association may have its own covenant that talks about it, and that says you can't build anything at least 3 feet from the property line. So it's a 3-foot setback, which is obviously much smaller than the county's 10-foot requirement. So if a homeowner wants to build a shed and they submit to the association for approval, and the shed is, they want to build it exactly, 3.5 feet from the property line. The association won't deny that shed on the basis that it's 3.5 feet from the property line, because our requirement is only 3 feet. However, if the homeowner builds that shed at the 3.5-foot line, the county, if somebody submits a complaint, the county can come in and say, hey, you violated county ordinance. And you cannot have your shed there. And they're going to issue a violation. They might impose a fine. They may require you to move it back. But that's going to be the county that does it, not the association. So that was the example, is that you got two separate entities enforcing their own requirements. And so ultimately, if that homeowner wants to be in compliance with both the HOA requirements and county requirements, that shed needs to be back at least 10 feet, because that's the only way they can do it without violating one of the rules or one of the requirements. Hopefully that makes sense. Did I miss any of the questions? Well, you know what? I thought I'd have more questions with this. Does anyone have any other questions? Otherwise, we are going to end this fairly early today, which is fine. I just want to make sure I get everyone's questions answered. Okay. Who is responsible for? Sorry, that didn't come through. Who is responsible for something? Getting the 67% approval. Oh, well, it would be both. I mean, it would be, the master would have to agree to allow the sub-association to try and defect. And so the master would have to, present something allowing the 67%, and the sub would have to present it to its people. So it'll be both. The answer is both. Sub covenants state that there is an obligation for the sub-association to pay master assessments. If the PR covenant, in the PR covenants, it states homeowners are responsible to pay all assessments and other charges such as fines, fees, interest, late charges, etc., and other amounts to PR. And what is PR? I'm not sure what that stands for. PR is master. Okay, sorry. Okay, so basically, the sub-association says, the sub-association covenants say that the sub-association has an obligation to pay assessments to the master on behalf of its owners, and the master association says homeowners are responsible to pay all their assessments and other charges, such as fines, directly to the master. So there's a contradiction there. In those types of situations, we really look at the order of, I think, when each document was recorded. Typically, the master association comes first, right? It's created before the sub-associations, and so that declaration is recorded first. And therefore, anything that's recorded afterwards, if there's a conflict, we can always argue that, first in time, first in right, that the conflict must be resolved in favor of the document that's the earlier. But that's not necessarily the case. And in these types of cases, hopefully the two communities can work together to figure out something that works for them. And perhaps they enter into an agreement between the two HOAs as far as the process that they're going to agree to follow with respect to that type of situation. Again, there's no black and white, there's no one size fits all here. So a lot of it might just be negotiating something that works for your communities. Any other questions? All right. Well, we're done. 10 minutes early. You still get your 1 credit. The slides will be emailed to you along with your credit. So yes, you will have all of it. Thanks so much for attending, and we'll see you next time. Hi, everyone.